SJC-12597, Commonwealth versus Espinal.
Ms. Conley, good morning.
Good morning. May it please the court, Rebecca Kiley on behalf of Arismendi Espinal. Mr. Espinal is an immigrant to this country who does not speak English. For that reason, his trial counsel was rightly concerned that some jurors might harbor a bias against him, and she requested a single collective voir dire question directed at that potential bias or prejudice. The judge denied her request and asked no questions regarding Mr. Espinal's use of a Spanish language interpreter. That was an abuse of discretion.
Question have sufficed?
I'm sorry?
A written question have sufficed?
Under the case law, I think if this was a question that was covered by the juror questionnaire, then yes, as long as...
Or a special juror questionnaire that the judge could have put together?
Yes. Yes, I think it would have.
Do it by written question?
I'm sorry?
Would have been okay to do it by written question?
I believe that, yes, under the cases, it would have been.
Now, are there any cases that you can point us to that deal specifically with collective voir dire questions as opposed to individual voir dire questions?
The huge weight of the cases are regarding individual voir dire requests, but I think that they are instructive on this issue.
Yes, but can you point us to any that deal with collective voir dire?
Justice Link, I don't, off the top of my head right now, I don't think I can.
Any of the state?
I did not look at how other states approach this.
Is that because most of the collective questions are governed by statute, right?
Well, I think it's because the issues that tend to be raised on appeal are issues where the defendant has requested an individual voir dire question and it's been denied. And often the reason that this court or the appeals court has affirmed in those circumstances is because although the judge denied the request for individual voir dire, he or she did ask a collective voir dire question that got at the same issue of bias or prejudice that was the subject of the request for individual voir dire.
Let me ask you a question. What if only a Commonwealth witness needed a translator? Would they still have the same entitlement to the collective voir dire question that you're arguing?
Well, they could certainly ask for it, and I don't think a judge would abuse her discretion in asking the question. The purpose of the statute is to protect the defendant's right to a fair and impartial trial, and that's obviously what we're concerned with in this case.
Well, but that's the statute.
I thought the government has a right to a fair trial. Because the government can raise peremptory challenge issues, right?
Yes, that's right. And I think the government also has a right to knowingly exercise its peremptory challenges.
Right, so you don't want us to hold that the government doesn't have a right to a fair trial?
No,
right?
I don't. I think it would also, I think this is fair game for either side. But I think we are, because the defendant has a constitutional right to a fair trial that is protected by the statute, I think there's a particular concern in this case that was not adequately guarded by the judge's conduct here.
Now, the argument, of course, is that there was a general question, right, to the panel about
Yes.
bias, and in your view is that it's not enough. Because the jury could clearly see that there's an interpreter being used.
I don't think, right, and I think I explained this in footnote 21 of my principal brief, but the question at pages 32 and 33 of the first day of trial transcript, the lawyers are introduced. The defendant is not introduced, the interpreter is not introduced. And then at page...
Interpreter there already.
Was that?
At the time that this is happening, the interpreter was already interpreting for the defendant.
That's right, but it's only...
They could see that.
Well, I don't know that they could see...
He was sitting there, wasn't he? He was at trial. It was his trial. He had a
Yes,
right to be there.
they
and
could
to have a
certainly see the
translator.
interpreter. I don't think they could see what she was doing. And I don't think it's fair to assume that when one page later, on page 34, they ask this general question about, are you sensible of any bias or prejudice, I think it would be unfair for this court to assume that at that point, the jurors all would have already appreciated and understood that the person sitting next to the defendant was an interpreter and not a paralegal, an investigator, another attorney.
And do you think there's a difference between ethnic or racial bias questions and, I guess, failure to speak the language bias? I'm trying to drill down if they're one and the same.
Well, I think they're related.
Judge did, the question was asked, and the judge tuned into whether or not the victim and the defendant, the alleged victim and the defendant, were of different ethnicities, right? So,
yes, and I think he was focused on
our case law.
Well, on the categories of mandatory individual voir dire, which is not what the request was for in this case.
So is there a difference because the parties are introduced and the person has a Hispanic last name?
Right.
And I'm sure the witnesses are introduced, and they certainly had similarly Hispanic last names, correct?
Right.
And so the judge asked, is there anything about this case that would cause you problems? And that there's an inquiry, but you think it should be a step further where it talks about language bias?
That's right. I mean, that is what defense counsel was particularly concerned with. And what she said, and what is true, is that there are many Americans who believe that if you immigrate to this country, you have an obligation to learn English, and that if you don't do that, something, that you've done something wrong. And
Was the complaining witness, did that complaining witness require a translator?
she did not, no.
Did not. Some of the government witnesses did though, right?
One did. The defendant did not testify but required the use of a Spanish interpreter. His only witness, who was his longtime partner, required the use of a Spanish language interpreter, and the complaining witness's father also.
Would the juror then say, this biased juror then say, well, geez, why isn't the government's witness, why doesn't that person speak English?
Well, they might have, and I think, a question directed at this issue could have benefited both sides potentially. But again, what we're particularly concerned with here.
Language bias is a form of ethnic bias?
Well, the United States Supreme Court has suggested as much in Hernandez versus New York, which is, I did not cite that case in my brief, but the amicus brief does cite it. And they note that language differences can,
But didn't that have to do with jurors not being able to consider the interpreter's interpretation of testimony, even if they spoke that language?
Yes, that's right. And so I should be clear, I think the part of Hernandez that I'm referring to here is dicta, but it is, the court did acknowledge that language differences can be a source of division and that they're often either a trigger for or a reflection of what the court actually called racial bias, but I think we could also consider ethnic bias.
Aren't we go ahead.
I guess the concern is this. You've got an interpreter there, and you've got the finale there, and it seems to me a good idea to ask that question. But you have to balance that against that impanelment comes with many, many different issues, and now we have attorney voir dire, at least in the Superior Court. A lot of judges will do individual voir dire even when you don't need to eyeball the witnesses and have the attorneys have a chance to size them up. Are we now going to, in what is now a very strenuous process, take away more discretion from the judge who's really at ground zero, going through with the attorneys a very difficult process of impaneling a fair and impartial jury? Because it's an add-on.
I'm sorry,
It's something else that we're saying, you don't have a choice here.
Well, yes, but I'd like to emphasize that what I'm asking for here is not a new rule. The first paragraph of Chapter 234A, Section 67A, requires the judge, upon motion, to inquire as to whether any juror is sensible of bias or prejudice. And what this court has repeatedly held is that the judge must exercise discretion to determine what questions are reasonably necessary.
Exactly.
Yes, and our position is it was an abuse of discretion in this case, where you had this area of very common bias. And where the request was for one simple collective voir dire question that I would submit would not have seriously burdened what was in fact a very short impanelment process.
Aren't you back next year asking for that to be part of an individual voir dire?
Well,
If you win?
I've read those cases, and I don't think I'd have a great shot, so I'm not sure that I am, but this is an area where judges are tasked all the time with exercising their discretion, and in this case, I think it was an abuse of discretion to not.
Right, but
But it would
I
be
guess
in any case, wouldn't it?
Right.
It would be in any case where a defendant required the use of a Spanish language interpreter, and where he requested the question.
Well, I assume any language, not just Spanish.
Sure, yes,
But
yes.
aren't we interjecting the issue? I mean, we have a case in which both sides are requiring Spanish translators, and we're interjecting this thing that's almost probably on no one's mind. Isn't that a problem? There's no indication, I mean, if you ask the normal bias question, someone says, I think everyone should speak English, and then we know we have a problem, then we can follow up. But do we really interject this into this case, particularly where it's the same, it's not even cross-ethnic testimony?
Right. So first, I would like to emphasize, I think there was no chance that any juror here would have volunteered a bias against Spanish
not?
language
If you feel
speakers.
that strongly
Because they
about it.
didn't know. Because they did not know that the defendant did not speak English, because they weren't told, right? The issue here is that the judge would not advise the jury of the fact that gives rise to a very common bias or prejudice. My second response is that under Commonwealth versus Prenti, and also under United States versus Rosales-Lopez, a United States Supreme Court case, the courts have said that this is the defendant's decision to make. And in Prenti, I believe, Justice Lenk, that you wrote that, yes, there's a risk of injecting this into the case, but there is also a risk, if you don't ask it, that you will end up with a jury that has people on it who are biased against the defendant for this kind of impermissible reason. And that's the defendant's choice to make. He runs a risk, but he asked for it in this case, and it should have been asked. I also...
I'm very interested in the circumstances here. I mean, are we really saying to the judge has to do the question, or is it that the judge has to simply give over the information? Or that information has to be there. For example, if the translator had been introduced as the translator to Mr. So-and-so and Mr. So-and-so and Ms. So-and-so.
I think if the translator had been introduced and their role had been explained, that they were interpreting for the defendant, that I would have a much more difficult argument.
Which would be a good practice, too.
Yes, it would be.
And quite frankly, asking the question might well be good practice. But the problem is every single case is different. So you got a defendant who is using an interpreter who's not going to testify. The Commonwealth, you have a U visa rape case, and the impeachment is the U visa.
That was not permitted, Your Honor. There was that issue did not get raised at trial.
No, I'm a hypothetical.
Oh, I'm sorry.
I'm in the hypothetical.
Okay, there was a request for that in this case.
Yeah, I know. It's a hypothetical.
Okay.
And so now you have the Commonwealth is the one with the interpreter, and the defendant's not testifying, and maybe the judge, taking into account all the other questions and multiplicity of issues, decides, I'm going to, in my decision in this circumstance, is to exercise my discretion not to ask that question, because as Justice Garcia and Cipher point out, if you win here, it's not discretionary anymore. And I'm just concerned, as I said in my other question, I'm concerned on imposing on the trial judge's exercise of discretion in impanelment, as long as the judge in good faith believes he or she is trying to get at whether this is a fair and impartial juror.
Can I just
Right,
add to that, because you said you're not looking for a new rule, but it seems like you are, because right now it's within the judge's discretion to figure out how to find bias. But it sounds like, and you can correct me if I'm wrong, but that you're looking for a rule that a judge has to ask a question about bias when the bias is a common one and isn't necessarily obvious. Is that fair?
I think it is, but what I would say is, what I'm arguing is that in this case, it was an abuse of discretion to not ask the jury a question about this common and not obvious area of bias, and also a substantial bias, right? This is not...
But how would we know in this case, as opposed to Justice Budd's question, how would we know in this case that this is an abuse of discretion? What are the distinguishing features for us?
Well, what I would point to is, and there are many, obviously there are many cases in this area, and there are not very many winners for defendants, but what I think distinguishes this case from all of those is that in every other case I could find, there was some reason for us to feel confident that had the bias existed, it would have been elicited, if not by an individual voir dire question that was denied, then by apprising the jury of the facts of the case or asking a collective voir dire question. And so, for example, in Commonwealth versus Rivas, which the Commonwealth relies on, the judge wouldn't ask a an individual voir dire question on domestic violence, but he told the jury what the case was about, and 12 of them affirmatively responded to the domestic violence issue and then came up to sidebar, and 10 of them had to be removed. And we see that over and over again in the cases that what this court says is the judge took adequate measures to ensure that the defendant's right to a fair and impartial jury was protected.
Does this
And-
right also apply if you speak with an accent?
I'm sorry?
If you speak with an accent, should we ask the same question? If you have an accent, is that enough? Forget about you need a translator if you just have an accent.
I think that's a weaker case. I don't.
Why? It's the same issue, isn't it?
Well, I don't think it is the same issue. I think the question is that I think that many people in our country are bothered by the presence of immigrants who have not learned to speak English, like the defendant.
I understand this was in the district court, but.
That's right.
But in the Superior Court, this seems like a natural type of attorney voir dire type of question, wouldn't it be?
It would be, and I think now in the district court it could be as well. At the time this case was tried, attorney-conducted voir dire was not permitted in the district court.
These are all subcategories of what doesn't rise to the level of individual voir dire, right? So you're not saying it's individual voir dire, you're saying it's kind
Right.
of lesser, but should be required of the panel. What about a defendant or one of your clients who has a substance abuse disorder, right, who's drug addicted, and there's incredible amounts of bias against people
Right.
who have substance abuse?
I think the jury should be apprised, if that's a fact that's going to be relevant to the case, I think the jury should be apprised of it before they're asked
So would that be like this, where it doesn't rise to the level of a full-blown individual voir dire, but you would say it's an abuse of discretion not to ask the jurors, do you have particular biases against people who have drug addiction?
I would, and I think, for example, that Commonwealth versus Ashman is.
I'm just wondering where is this going, these subcategories of lesser, doesn't rise to the full-blown level of individual voir dire, which would examine particular societal biases.
Right, well, what the statute says, so the Commonwealth's interpretation of the statute is that you have to make the same showing either to get collective voir dire under the first paragraph or individual voir dire on the second paragraph, which is a substantial risk of an extraneous influence. And my position is, first of all, that's not consistent with the plain language reading of the statute, which doesn't have that requirement in the first paragraph. But second of all, it puts defendants like Mr. Espinal in an impossible catch-22, where they know there's a common and substantial, a serious, ethnicity-related bias that's potentially in the case. They can't ask the question. They can't identify a particular juror where there's a substantial risk of an extraneous influence, so they can't get the individual voir dire. That is not a system that I think we can be particularly confident will
right now
produce fair and impartial juries.
Right now, it's left to the discretion of the judge, but you think there are some categories we should say doesn't rise to a full-blown level of individual voir dire, but when there's a particular bias, it's an abuse of your discretion not to ask these particular questions.
I think it was an abuse of discretion here not to ask the single collective question.
Is it limited to ethnicity, your new rule? Meaning, because, people are prejudiced against people on public assistance. Are we gonna, is that the next set of questions?
Well, again, I want to emphasize I don't think I'm asking for a new rule. I'm just asking the court to apply the first
But
paragraph
I'm just trying
of
to
the statute.
understand how far we're going, because we're moving. And is it limited to ethnicity, or is it anytime the public has biases?
I think that it probably makes sense to think about it in terms of a common and substantial bias that we have a real concern could interfere with deliberations. And so, for example, if the jury is going to learn over the course of the trial that the defendant is
Any common bias? Like we don't like Republicans or Democrats?
Sorry, this is what I was
Okay, go ahead.
getting to. If we're going to find out that the defendant is a Baltimore Orioles fan, like in New England, that might be a problem for some jurors. I don't think there's.
Try
Yeah,
Yankees.
you try Yankees, yeah.
That one I actually think is a little tougher. I might want.
That's why
I
I said
think we might
Orioles.
want the question for a Yankees fan. But I don't know that we would be.
Doesn't that reveal the problem? We're getting into this kind of extremely subjective. It's the Yankees versus the Dodgers. Are we really going to go there?
I think the question that we have to ask is, are we concerned that this bias might have impaired the ability of the jury to be fair and impartial? And in this case, I would suggest that anti-immigrant and anti-foreign language speaker bias is still very real in our society, and there was no assurance whatsoever that everybody who sat on the jury was free of those biases. And I don't know how we can look at that and think that this was a fair trial for Mr. Espinal.
But you're claiming that's always structural error. The failure to give an instruction as an abuse of discretion or in violation of a rule is always a structural error because we can never ascertain the consequence.
Well, I think that's consistent with this court's cases. In Commonwealth versus Wood, what this court said is that the right to a fair and impartial jury is so fundamental to the right to a fair trial that an infraction of it is we always presume prejudice.
So isn't that part of the problem? That the more that we require, the more we're going to be required to vacate convictions because of structural error arising from a judge's failure to exercise sound discretion in these matters?
That is the result.
That would be the result. I mean,
Yes.
the problem is that we don't have any middle ground. It's either structural error, conviction is vacated, or nothing. I mean,
I think that's
the
right,
problem.
but this is a statute that's designed to protect a fundamental constitutional right, and I don't know how we can do that without presuming prejudice. And the court has done it in Wood involves the erroneous denial of a peremptory challenge, which frankly I don't think goes as directly to the right to trial by a fair and impartial jury, because obviously a juror who would be removed via peremptory challenge is a fair and impartial juror. And in this case, we just don't know that the jurors on Mr. Espinal's trial.
What if there's an issue, as there is in the very first case we heard today, about whether the defendant truly is unable to speak English, but has an interpreter? Speaks some English?
I think if the defendant and his lawyer, with the court's agreement, have decided that he would benefit from the assistance of a foreign language interpreter, that the question should be asked, because the bias, I think, would remain the same.
And would the Commonwealth object, saying, Your Honor, that would be the court telling the jury that the person's unable to speak English, and we claim the person actually is able to speak some English, enough to be able to make a voluntary waiver of Miranda rights?
I'm sorry, and that.
I guess it was the first case we heard in which the Commonwealth argued that the individual understood English well enough, even in English, to voluntarily or to knowingly waive Miranda rights, albeit the problem with the Spanish translation. We do get cases in which there's ambiguity as to how well the individual speaks
Sure.
English.
I mean, and in that particular case, it's the Commonwealth's burden to prove that. But in this case, I don't think there was any dispute about Mr. Espinal's inability to speak English.
So what information is it that you want the jury to have? I mean, that would have been enough, so that the jury, that when he asked the general question, it would have been comprehensive enough? Or she
Just
asked
that Mr. Espinal was unable to speak English and would be requiring the assistance of a Spanish language interpreter.
Or that he just required the services of a Spanish language interpreter?
Okay. But I think in either case, I don't think it is very far-fetched to think that some jurors would have responded affirmatively to that question.
I guess what really troubles me is I don't know what they could see. And the record is not clear on that. I don't know what they could see. Could they see it getting translated? Does it matter what language it was? They know what the names are.
I assume that they could see the interpreter, but she was not introduced. And so again, I don't think they could have known.
Well, don't they wear headsets?
I'm sorry, I don't know the answer to that.
Or is it just they're whispering in his ear?
My understanding was that she was just whispering in his ear. And again, this was very early on.
Really is not kind of illuminating, let's say, about what it was that the jury could have seen, or the prospective jurors could have seen, or intuited about what was going on with respect to the defendant.
That may be so, but in the absence of an introduction of the interpreter and explanation of who she was, I don't think we can assume that the jury would have understood.
Burden to
the
show
role.
what happened and what didn't happen.
Right, and I'm asking the court to draw the fair inference that the jurors would not, and it's literally a page after the introduction of the attorneys that the fair and sensible.
No, but he's already there. He has a right to the translator at the beginning of the trial, right?
Right.
So he's already getting translations while this is going on.
Right. What I mean is I think that the impanelment starts on page 31 and that it's on page 34 that they ask, are any of you aware of any?
At what point in the trial did he have the right to the interpreter? Beginning of the trial, right?
Yes, right.
And that was not when the jury was just being impaneled, right?
Right. The jury was not present for the argument on motions in limine, which is when the trial began.
For which he already had his translator.
He did. But obviously the jury didn't see that happening.
No, but they would have seen when they came in. I'm just saying, the entire time, they would have seen him having a translator.
Well, they would have seen a person speaking to him. Again, I don't think it's a fair inference that a lay jury would know this person is an interpreter and not this person is an investigator, a paralegal, a second attorney on the case. There are very often a second attorney sitting at counsel table with a defendant or a paralegal sitting with the defendant.
But hopefully not constantly whispering into their ear.
Well, sure.
Ms. Colley, with the chief's permission, can you, so that we didn't let you get to the other issue. And you probably prepared on it. So first complaint and the issue of whether or not in the first complaint the jury's being told about, in general, victim of sexual assault may have reasons not to immediately disclose.
Right.
Can you at least give us a short answer to that issue?
Sure. So I think it's clear under Commonwealth versus King that the purpose of that language in the instruction is to dispense with the perhaps commonly held but also erroneous assumption that victims of sexual assault, that a report of sexual assault is more credible if it's made promptly. And so the instruction explains to jurors that they should not assume from a delay in reporting that the report is not truthful. And what defense counsel argued below and what I argue here is that in a case like this one, where there is really no delay in the report, that including that language in the instruction, I think actually thwarts the purpose of King and does the opposite of what the principles in King Express ask, in that it suggests, again, that King uses the language of a quote-unquote real victim will report immediately. And by doing that, it injected an issue in the case that was not relevant to the case, and I think it improperly bolstered the complaining witness's credibility by telling the jury that they should be particularly likely to believe her because she didn't delay in making the report. And I do just want to, if I could just emphasize, the request below was that the final sentence of the King instruction be omitted. And then the defense counsel offered as an alternative that supplemental language could be provided, but the focus was just on omitting the language. I think I believe the Commonwealth referred only in their brief to the request for additional language, but that really wasn't the focus of the request below.
All right, thank you.
Thank you.
Ms. Sullivan.
Morning, Catherine Sullivan for the Commonwealth this morning. I guess I'd like to start by addressing Justice Lang's first question. These cases are cited in my brief throughout. Chalene, Commonwealth versus Chalene, and Commonwealth versus Lopes both dealt with
Chalene
questions.
and Lopes are the only two cases that they deal with collective?
They're not the only two, but I rely substantially on them throughout my brief.
They're the only ones you cite?
No, there are other ones, but I think those are representative of the approach that this court takes with regard to questions requested on collective voir dire, and that is what Justice Lowy was getting at, which is that it's up to the judge to determine which questions should be asked to ensure a fair and impartial jury. And that extends to questions asked on collective and individual voir dire, with the exception of those that are mandatory under the statute.
Well, what makes you say that the standard should be the same in terms of what happens? I mean, the individual voir dire cases are different in determining what kinds of, when they're necessary.
Well, that's my point. They're not different.
What makes you say that? Because that's what it says in Chalene and Lopes?
The way the court approaches those questions is questions to the collective veneer is the same way the court approaches questions to the individual voir dire. That's what I'm saying. Okay. Is the court requires that the same standard be met. that there be a substantial evidence of an extraneous issue that might affect the jury or the case itself. And those extraneous issues depend on circumstances. The Supreme Court, at one point, I think, in Restaino, calls them triggering circumstances. There's certainly, and that's explained in Hernandez, which is cited in the amicus brief. It goes through the history of the Supreme Court's treatment of racial prejudice. The problem here, and why the judge found himself, I think, in this position, was the initial question requested by the defendant was a terrible question.
What was it?
Do you have any problem with the fact that the defendant requires a Spanish language interpreter? What does that question mean? Do you have any problem with? And then when the
The other
judge...
questions that were asked, did they not take that form?
I'm sorry?
Did they not take that form? Other questions that may have been asked? Did you have any problem with?
I can't...
Do you have any problem with, was that a form used in other questions that were asked of the jurors?
No, this is the last question in the defendant's motion for questions asked on collective voir dire. And so when the judge saw that question, he came back to the parties and said, I'm not going to ask that question. Or he included it in the questions he wasn't going to ask. And the defense counsel came back and objected, saying, I think it really is a question of racial prejudice, and then launched into an explanation that included that her client was a naturalized citizen, and there are a lot of people that might have a bias or be prejudiced against naturalized citizens whose first language is not English.
Assuming that we could get it in the right form,
Right.
there would have been no problem with the judge saying, okay, I'll ask a form of that question.
No. And to be clear, and this is throughout my brief and the defendants acknowledged it, the Commonwealth never objected to the question, even in that form. So regardless of what the defendant's trial counsel was actually trying to get at, which is unclear in the first instance, the Commonwealth didn't object. But whether it might have been better practice, as Justice Lowy said earlier, or whether it was an abuse of discretion not to give the question, are two completely, they're related, but they're two separate questions.
What do you make of the out-of-state cases that the amicus has cited?
Well, I think it's
That,
interesting.
Other states like Iowa are basically taking this head on and saying, we really need to ask these questions.
I think it's interesting that, and that's why I got to the initial question asked by the defendant. It's interesting that the amicus focuses on equating language with racial prejudice, right? I mean, that's what.
Well, actually, it
That's
has
what
to
he's
do with
trying to
immigrants who don't speak English.
Well, that also, with prejudice.
Yeah.
That's the next step.
Yeah.
I think, he's limiting the language issue to those immigrants.
Yeah.
Right. So I think that when race is inextricably linked or part of the circumstances of the case, then a question is proper, and that it should be up to the defendant. And that's,
Just with race.
I'm sorry?
Just with race?
Well, if there's another bias that he feels the jury might be sensitive to, that's linked to the circumstances of the case. That's the thing that distinguishes this case from all the other cases, I think. Race was not an issue here. And the defendant's, the trial counsel's assertion that race should be inquired of just didn't make sense,
Well,
given the circumstances of the case, which is what the cases rely on in holding that the question is necessary.
almost seems to me like there's a question about, you're going to have mostly white jurors who are going to be citizens themselves, some of whom may have reflected the general view, apparently a fairly widespread view, that most people should speak English if they're in this country, and if they don't speak English, it's a problem.
Well, let's just say that at trial, the defendant didn't make any of the assertions that are contained via survey or law review or other cases that exist in the briefs on appeal
Assertions, what do you mean?
about what
Defendant
you
didn't tell the judge that? about
what you
the-
just spoke to, that this is a widespread bias.
Okay, so you're saying that this is something that the defendant should have advised the judge of?
certainly had an obligation to establish a foundation
Okay.
for the question, and he didn't do that here, and my brief makes that clear, that he didn't. And that's what Shalene, excuse me one second, talks about specifically, is just this widespread belief, this anecdotal assertion isn't enough.
But, sort of related point maybe, I'm not sure how helpful this is as a general question. When I asked the question, I mean, I hope I did it at the sidebar or during the witness stand as part of individual voir dire, because the overall point, at least from my experience here in jurors, there's validity to the overall point. Unfortunately, too many people make assumptions and tie it to race if somebody doesn't speak English. And it's not that they don't speak English, that's not even the issue. Many people use an interpreter who speak English pretty well, but like our first case, maybe not well enough to deal with inferences and words like that. So if you're going to do this, wouldn't it be done as part of an individual voir dire request, and then on appeal, if it's not allowed, analyze that under an abuse of discretion in that particular case?
Yes, that would be, I believe that would be the appropriate way to proceed, but also.
Sorry for the leading question.
I appreciate them. It also is in sync with our analysis of other questions asked concerning racial bias on individual voir dire. This court has repeatedly said that questions about racial prejudice should be asked individually at sidebar, that the general collective veneer might not feel comfortable raising their hand in response to a general question. So sort of flies in the face of, what the defendant is trying to assert here, that it should be asked generally. And the judge here did ask very specific questions regarding bias. He asked every single person that came up. He told them about the case. He told them that it was a sexual assault case with a minor. He told them that it involved, that he asked them about bias. And then at the end of the case, he also instructed that they could not allow any racial prejudice or other to interfere with their determination. So yes, that would be the better way to proceed. I think intruding on the trial court's discretion here is not appropriate with this kind of question. And then where do we stop? And to Justice Budd's question earlier, where do we stop? Or Justice Kafker's, is there a bias against people that wear glasses or people with red hair? Where do we stop? And hasn't this court consistently said the trial judge is in the best position to determine that? I'd also like to just state for the record that the interpreter was wearing, or the defendant was wearing headphones at trial.
And do we know that from the record? Is that in the record?
For the record. It's not in the record,
So
but I can tell you anecdotally that the defendant was wearing headphones, and the interpreter sits behind the defense. The defendant sits next to his counsel, and the interpreter sitting behind them. So the defendant had his earphones on the entire time.
And because you were there?
I'm sorry?
Because you were there?
No, I wasn't there. I spoke to the trial attorney yesterday.
Okay, so how do we?
So I don't have
so
personal knowledge, but I've.
If that were to matter, how do we use it where it's not presently in the record?
It's just in response to Justice Lank's question regarding her supposition that most defendants wear headphones. So I just was trying to be helpful in that regard. I'd also suggest that, to Justice Kafker's point, that the judge made a determination that he wasn't going to inject race or racial bias or the issue of racial prejudice into this case, where it wasn't one of the extrinsic factors to the circumstances of the case. And I think you can come to that conclusion upon a close reading of the transcript. Prior to the impanelment of the jury, the Commonwealth submitted a motion in limine to preclude the defense from asking any questions about the defendant's immigration status. Not the defendant's, I'm sorry, the victim's immigration status. Counsel for the defendant stated that she wanted to get into that issue because she believed that once the victim had gone to police or DCF with her story, then she was more likely to adhere to that story at trial because of the consequences arising from reneging on those claims at trial and the consequences from the police. The judge rejected that argument and precluded and allowed the Commonwealth's motion and precluded the defendant from raising the issue of the victim's immigration status. So the judge was on alert to this issue. And I think that explains why he rejected the notion that racial prejudice or bias should be asked of jurors, because it was not an issue in the case.
Was that a motion in limine before trial?
Yes.
Okay, so he
Yeah,
knew about
it's
it.
in the record.
He knew about it before he made the decision as to the question.
Correct, and it's on the record. It's in the first volume at pages 12 or 13, 14.
Can I shift gears and ask you about the investigator? To what did the investigator testify? Did the investigator testify as to what other witnesses told, were what
No.
people that he had interviewed said?
He testified to what the defendant told him.
Just what the defendant told him, not what anybody else told him?
Just what the defendant told him, and he also testified to, I think he testified to what Concepcion had told him about the fact that she had been in the shower for a minute. He testified to that on rebuttal.
On rebuttal?
On rebuttal.
Yeah, but,
because
you know, the objection, though, is by asking that question of the DCF worker,
Right.
it's latent hearsay. When you say, who else did you talk to? So it's it's latent hearsay. And what the defense is saying here is that by asking that question, what you're doing is you're accumulating his or her entire investigation and giving this DCF witness the imprimatur as sort of a truth finder, as my credibility
Right.
is on the line. And it's really making the Commonwealth versus Arana objection that this is just really what is everybody else saying about this without some independent relevance. And the independent relevance that the judge relied on, well, that's what he does. Well,
Right.
that's not going to do it if the defendant is right.
Right. So I understand Stukich. I'm not sure of the case you just cited. But the judge was aware of the issue, right? So when the defense counsel objected, he immediately questioned the Commonwealth, questioned the prosecutor, where are you going with this? And he cut that off, right? He cut off the investigator's testimony about any other conversations. And it was his understanding that the investigator was only testifying to what he did.
Yeah.
And so I think that was proper, where it laid a foundation for the defendant's statement. I'm not sure how else you would get in that statement to
Well,
Mr. Vigo.
the implication of the question is he talked to a whole bunch of people because that's what he does, that's his job.
Well,
Whether that's true or not, that's the objection and what's coming across in the
let's
brief.
assume that it shouldn't have been allowed. The defense counsel had already asked the victim and her father if they had spoken to DCF on cross-examination. So asking, his saying that he spoke to them or spoke to people, the jury already knew. It was already in evidence. So the likelihood of extra, is cumulative, and
And you say it's not preserved.
I say it's not preserved because the way you just explained it was not at all how the defendant objected to it at trial. In her motion objecting to first complaint testimony, there's one line that refers to Stukich. And the only time she raised that issue during trial was when she started going off track a little bit in response to the Commonwealth's motion to eliminate to exclude the immigration status. And throughout, all she said was it's not relevant, and it was on completely different grounds than are alleged here. So I maintain my argument that it's not preserved for those reasons.
Okay, thank you.
Thank you.